Welcome to the Nevada Advantage in Context, comparing today's top trust jurisdictions. My name is Teal Schoonover, and I'm a co-chair of the Beverly Hills Bar Association's Trust and Estates Law section. We are thrilled to have you join us today. Before we begin, I'd like to take a moment to acknowledge Nancy Sanborn and Brian Joy of the Sanborn team. Nancy and Brian have been the official sponsor of the Trust and Estates section since 2006. In addition to the Sanborn team, the Trust and Estates section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Leah Momsius to provide this month's legal updates.
Thank you very much, Teal. Per Executive Order 14247, effective September 30th, 2025, paper checks are being phased out for all payments from and to the IRS. There's no exception for trusts and estates. So that includes estate and gift tax payments, which must now be made, quote, as soon as practicable. Either one, electronically using the Electronic Federal Tax Payment System, EFTPS, or two, via same-day wire directly from a financial institution to the IRS. Unfortunately, both options require advanced planning. The same-day wire payment option may involve additional costs, such as wire fees, has a cutoff time of 5 p.m. Eastern, and requires that you provide your bank with a completed same-day wire taxpayer worksheet, which calls for various codes depending on the type of payment you're making. Meanwhile, the EFTPS option is free, but requires an enrollment process that takes a couple of weeks to complete, including having the trustee or executor register for EFTPS online, then waiting to receive a PIN from the IRS via snail mail, and thereafter returning to the EFTPS website to activate the account. Now, it does appear that there is a ramp-up period for making electronic estate tax payments because there is still information regarding paying by check on the IRS's website, but we recommend practitioners begin acquainting themselves with the electronic payment options sooner rather than later. And that's your legal update for February 2026. Over to you, Aubrey.
Thanks, Leah. Now onto the program. Today's speakers are Kristen Mattioni and Robert Rankin. Kristen D. Mattioni is Vice President, Associate Counsel at Whittier Trust, where she assists with the firm's legal affairs, advising on trust, fiduciary, corporate, regulatory, and business matters. She brings nearly a decade of experience in trust and estate law, having previously practiced with Snell and Wilmer LLP and Maupin Cox and Lagoy, advising high net worth individuals on estate planning, administration, and business succession. Kristen earned her BA in International Affairs and her JD, both magna cum laude, and is actively involved in professional and community organizations in Nevada. Robert W. Rankin is Executive Vice President, General Counsel at Whittier Trust, where he oversees the legal affairs of the firm and its affiliated entities. He brings more than 20 years of experience advising closely held businesses and high net worth individuals on business succession, estate planning, tax strategies, nonprofit matters, and trust administration, and previously served as a shareholder at Clark and Trevethick and as Senior Vice President, Trust Counsel at Fiduciary Trust International of California. Bob holds a JD from Loyola Law School, a Master of Business Taxation from USC, and is a recognized Southern California super lawyer and frequent speaker on tax and trust-related topics. Please welcome Kristen Mattioni and Robert Rankin.
Thank you guys so much. I'm going to try to get this up on the screen. Okay. Hopefully that is now working. Thank you so much for that introduction, Aubrey. We really appreciate it. And thank you to all of you who are tuning in and giving us the opportunity to speak with you all today. I think as our, short bios indicated, Bob and I are acutely aware of how valuable all of your time is, as both of us were in private practice before we moved in-house with Whittier. So with that, let's make the most of our time together today and dive into this. So today we are going to cover a topic that is very near and dear to my heart and potentially to many of you who operate in the realm of advanced estate and tax planning, although we probably call it something very different. I call it the Nevada Advantage. And I always preface when I talk about this topic by saying that I am entirely and completely biased in everything that I am going to tell you today. And that is because I am a fifth generation Nevadan. I'm obviously a Nevada licensed attorney. And so, I say all of that through that lens and through that context. But I hope that all of you will agree with me that despite my own internal biases about Nevada law and Nevada principles of estate and tax planning, it is really undisputed that Nevada has garnered a reputation for being one of the top trust jurisdictions in the nation. Specifically, Nevada has always been considered one of the big three, which is Delaware, Alaska, and Nevada. Although now I very much think that we have the big five, which includes Wyoming and South Dakota. And of course, there's always jurisdictions sort of vying for those top spots. But those are sort of the five that we're going to talk the most about today. And we will, of course, work some things about California into this presentation as well. And there are two things that Bob and I did want to kind of emphasize to all of you before we get too far into this. And the one of them is, and I think this is particularly important for those of you who are the next door neighbors of Nevada or whatever jurisdiction you're drafting trusts in. And I don't want this to get lost. And that is, you don't have to give up your clients just because they have trusts that are being prepared in one of these jurisdictions. We have many, many clients that we work with, and there are many attorneys that we work with who part of their practice is to do a review of these types of trust agreements. And I just think that's really important to emphasize. And the second thing I wanted to highlight, because I think it is really unique, and I don't know that it fits well into anything else we're talking about, and that's just sort of the way that the legislature works in Nevada. And our legislature meets every other year. So I do think that's something that's just a little bit interesting in Nevada and how our laws are shaped and how they operate. And so it's a little interesting. We have a lot of access to our lobbyists, and many of them are practitioners themselves. Some are teachers. A lot of them have other jobs, right? Because the legislature only meets every other year. So it's a really interesting way that our system, I guess, works. And so that's just something that I think is really important to talk about. So with that, we'll sort of talk about what we're going to cover with all of you today. So we are, of course, going to talk about taxes because you can't talk about any of the top trust jurisdictions without talking about taxes. Then we'll talk about asset protection, and specifically, we're going to talk about some of the things, not just asset protection generally, but about some drafting things to keep in mind if you are preparing these types of trusts. Then we're going to talk about the flexible and favorable statutes that exist, right, from directed trusts to decantings to NJSAs and notices of proposed action, as well as silent trusts. Then we'll talk about the perpetuities period, and we'll wrap this up with privacy and confidentiality. So as we work through this, if you have questions, feel free to put them into the chat. So, okay, taxes. So let's address the obvious thing first. In addition to the absence of state income tax on both individual and trust income, Nevada also does not have a gift tax, an estate tax, or other form of inheritance tax. It does not have a generation skipping transfer tax or GST tax, all of which, of course, make it a very attractive trust jurisdiction for estate planning and multi-generational wealth preservation purposes. I also just felt like I would throw this in there. I feel like property taxes are getting a lot of attention these days. So I did think that it was important to note that Nevada does also have very low property taxes. In fact, our effective rate is 0.45%, which is ninth best in the nation currently. But in speaking with all of you guys today, Bob and I did not want to leave anybody confused or to misrepresent that Nevada is the only state that, of course, has these beneficial tax laws. In fact, all of the big five that we just talked about, right? So all of the big five have these same tax benefits. There are just a couple things to bear in mind. So one is that Delaware does actually have a tax on trust income, but it only taxes residents. So if you don't have a resident beneficiary of the Delaware Trust, you're fine. Additionally, in 2023, Alaska was contemplating implementing an income tax to address some of their very serious budget deficits that they're dealing with. That didn't happen at that time, but it is something that is being kicked around in Alaska. So I think there's a couple other states that are maybe thinking about that too, right, Bob?
Right. Well, I'll just jump back a few steps. And it's great to work with Kristen, who's clearly passionate about the Nevada piece of this. But really, all of these elements that we're going to get into today will cover key reasons why these jurisdictions have modified the laws the way they have, with tax being mostly the primary motivating force. So we're going to see an ever-changing land tax landscape for the next few years. Recently, the state of Washington just implemented or is in the process of implementing a tax on $1 million income or more. If income is exceeding $1 million, then they're suggesting that there'll now be an income tax for those folks. And that's going to continue to change. One of the unique things about Nevada, and Kristen can weigh in on this as a generational citizen or resident, is the ability through their gaming and mining resources to continue to maintain this status. I think as these states, the non-tax states, these jurisdictions continue to attract people, the resources are stretched, and there's only one way to generate income, and that's through taxes primarily. So that'll be an interesting area to watch over the next many years as these things grow and the populations grow in Florida, Texas, to some extent South Dakota. People aren't rushing to South Dakota last time I checked, but Nevada is seeing some more inflow, especially the Northern California area. And it's going to be an interesting area to watch for sure. But this is one of the key components. It's really, less to do, obviously, with income as mostly, or even estate tax. It has mostly to do with the ability in many of these states to create a trust that will go on for multiple generations. Many of those states have perpetual, they've eliminated altogether the rule against perpetuities. And so what you have is an ability, as this graph shows, you don't have that loss in momentum in that 60-year period. So a trust is created on a death, not necessarily rule against perpetuities, but on a death, you're going to see on the federal level 40% removed from the assets that are growing. And that's something that's highlighted well here, and that's primarily focused on the state of California. We are seeing other states, again, Washington State and a few others that have implemented an estate tax, and that's something to be aware of as you plan. But the uninterrupted momentum of the ability of a dynasty trust to create wealth is pretty significant. And one of the things we've seen over the last 15 years is almost an uninterrupted growth in assets and creation of wealth. And while there'll be a market adjustment at some point, that wealth will be something that can be set aside, hopefully under the new Big Beautiful Bill and some of those aspects with a higher exclusion amount to take advantage of exactly this type of planning.
Great. So with that, we are going to sort of slide into asset protection. And I think everybody on this call probably knows, but asset protection trusts are highly valuable for select high net worth individuals. A properly set up asset protection trust can effectively shield any type of asset from all kinds of legal threats. So those can range from lawsuits to creditor claims to divorcing spouses. Now, as a matter of public policy, essentially every state recognizes in general the validity of spendthrift trusts to protect a third-party beneficiary's interest from creditors. But historically, many of those laws have been unenforceable with respect to a settlor who's also the beneficiary of the trust, such as what we call a self-settled spendthrift trust or a self-settled asset protection trust. In the since 1997, many states did enact legislation that extended these spendthrift trust laws to settlor beneficiaries. So what's actually easiest to do is, as I work through the next few slides, I'm going to start with self-settled asset protection trusts, and then we'll work our way into third-party asset protection trusts, and sort of talk about how this works. So, right, broadly, what is a self-settled asset protection trust? So a DAP, a domestic asset protection trust, is just an irrevocable trust that's established by the settlor for the benefit of the settlor and any other beneficiaries that they may want, in one of the states that allows for the creation of these types of trusts. There's currently 19 states, hopefully I'm still right about that, I did check, that allow for self-settled spendthrift trusts. And DAPs generally rely on the spendthrift clause and state statute to protect those assets contributed to the DAP from the settlor's creditors. And so sort of what's the requirement to have a DAP, right? So it has to be irrevocable. It cannot require that any part of the income or principal of the trust be distributed to the settlor, and it must be funded with must not be funded with the intent to hinder, delay, or defraud known creditors. You have to have a jurisdictional trustee, obviously, right? Sort of your jurisdictional hook in the DAP jurisdiction. And the trust has to contain a spendthrift clause that places a restraint on voluntary or involuntary transfers. I think it's really important to say that a primary power that cannot be retained is the power of the settlor to make distributions to himself or herself without the consent of another person, right? Where Bob and I are often seeing that, probably where a lot of you are seeing that, but our perspective might be a little bit different given that we're primarily administering trusts here at Whittier. Is right. You have to have distribution advisors. You have to have some usually it's better if it's an independent party, but an independent party who is sort of in charge of that. And so Nevada, right, is largely considered to be one of the best, if not the best jurisdiction in the nation for asset protection. We call them NAPs in Nevada, right? A Nevada Asset Protection Trust. And a big reason for this is, of course, that we're one of only 19 states that allow it. That's great. These self-settled asset protection trusts. But really the reasoning for Nevada being, well, truthfully, the leading jurisdiction in asset protection is for two reasons. And that's the statute of limitations period. And the second is the fact that we don't have any statutory exemption creditors. So basically, each asset protection jurisdiction provides a statute of limitations period during which a creditor can try to attach or make a claim on the transfer of the assets made to the trust by the settlor. Nevada is one of the only states in the nation that has a 2-year statute of limitations for both future and pre-existing creditors. Whereas that's usually like 4 years in many other states. I know it's 3 years in Delaware, to give that a comparison to one of the big five. One thing that I do think is worth noting for anybody who really is concerned about this is that every self-settled spendthrift trust is subject to a 10-year statute of limitations period in a bankruptcy proceeding, right? That's federal bankruptcy laws, federal. And so that's because the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 added new language into the bankruptcy code, and that's what governs fraudulent transfers and obligations. So, but that's the first reasoning. The second reasoning, which I think is arguably maybe a little bit more important for many of our clients, and that is because almost every asset protection jurisdiction has what we call statutory exception creditors or super creditors, super priority creditors. For example, a lot of other jurisdictions will allow for things like child support, divorcing spouses and alimony, maybe pre-existing tort claims. In Nevada, we do not have any of those. And in fact, the only states that do not allow for those are Nevada, Utah, and West Virginia. None of whom are, of course, in the big five except Nevada. So that is really the primary reason that Nevada takes first, I guess you could say, in asset protection. But there are some other considerations that I think you have to give attention to when you're considering asset protection. The first is, of course, the fraudulent transfer standard, right? So a standard case of a fraudulent transfer usually involves a debtor who gives property or sells it at a fraction of its value to like your family, your spouse, your kids, your best friend. And then that person kind of tries to aid you in the fraud. So obviously you have to be very well aware of that. Can't have any sort of asset protection for that purpose. You need to be aware of a trust decanting statute, which we will talk about a little bit later when we talk about decanting, but that can really matter for asset protection purposes. And of course, you want to think about things like ease of use, right? So a lot of jurisdictions will require an affidavit of solvency to make transfers to the DAP. That's not something that Nevada requires, just so you know, but you could have it if you wanted to. And there are certain jurisdictions like Nevada that allow the trustee of the DAP to distribute property to a settlor or beneficiary for the purpose of obtaining a loan, so long as it's properly secured, then that does not, and then it's reconveyed to the trust, then that doesn't necessarily have to be considered a new transfer. So these are just some things to take into consideration when you're looking at the Big Five or looking at asset protection jurisdictions, because it can really matter depending on the facts and circumstances of what you're dealing with your clients. Something else that can be really important for those of you who are drafting asset protection trusts or considering asset protection trusts, and that is the types of powers that the settlor can retain, right? These really do vary by jurisdiction, but these are some that you can have in Nevada. I've sort of listed them on the screen, so I don't necessarily need to go through every single one of them. But just know that these are sort of the ones that I highlighted because I do think they're important, right? You can remove and replace the trustees. Often that's really important, or the investment advisors. You can also exercise discretion still over investment. So the settlor could be the investment advisor. There's, of course, potentially some tax issues related to the FTB there. It depends on how conservative you want to be. But that's something to think about. The settlor can also be a co-trustee. Again, there could be FTB issues there. So, we have to think about California related issues for those of you drafting in California. But if you have non-California clients, it's something to consider if they wanted to be a co-trustee. You can also retain lifetime or testamentary special powers of appointment, which is kind of nice. So anyway, these are just some of the things that I think are important and that we put up there for you all to think about. So what are a couple other things maybe to think about when you have non-residents? So for non-Nevada, non-Delaware, non-Alaska, non-South Dakota, non-Wyoming residents, right? What are some things that maybe you need to be thinking about for those types of clients? And I think it's pretty obvious that conflicts of law is probably the biggest thing, right? In general, the full faith and credit clause of the Constitution requires, right, that states recognize the laws of other states. So unless those laws are against the very strong public policy of the home state. So that's the general rule. How helpful is that in practice? I think that's hard, right? We see in particular the FTB be pretty aggressive about these types of things. So you do want to be very careful about who you're naming to have various roles in your trust agreements, and being sure that you're staying on top. As Bob mentioned, right, these laws are evolving. Things are constantly evolving in not just at the federal level, which I think we're all pretty tuned into, but at each individual state level. All of these laws are evolving, things are happening. The case law is constantly changing, even though there's very limited case law in Nevada and in all of the Big Five that addresses these things, right? Because our clients settle, right? Like at the end of the day, most of the clients that we're dealing with don't want these cases heard before any type of Supreme Court, state or federal. And so, there's very little published opinions on any of this type of work. So those are the things to keep in mind. And of course, the Uniform Voidable Transactions Act, very obvious. Again, you can't set up an asset protection trust for a fraudulent purpose. I guess one of the questions that we get asked all the time is, can I be a non-resident though and take advantage of a Nevada asset protection trust? At least that's a question that I get asked very regularly. And really the answer is yes, right? In order to do that, though, it is really important, some things to think about and to consider if you are drafting these kinds of trusts for your clients. And the first, right, you want to name either a Nevada resident, a Nevada bank, or a Nevada trust company as your trustee, right? That's really how you would want to strengthen that nexus. A further way to strengthen the nexus is, of course, to set up like a Nevada LLC or a Nevada partnership or whatever it may be, depending on the type of assets. If you're just transferring marketables, that may not be as necessary, but depending on the type of asset, if it's like real estate or something like that, that is helpful to form an even stronger nexus to the state of Nevada. And lastly, right, while the traditional Nevada Asset Protection Trust is self-settled, a Nevada Asset Protection Trust may be specifically designed to not include the settlor as a beneficiary. And then they could potentially be added back in at a later date. We're sort of calling those a hybrid asset protection trust, and I won't take credit for coining that. I think Steve Oceans is the one who's a Nevada attorney who talks about this topic pretty regularly. That's how he drafts his asset protection trusts. But really what that sort of means is that the trust is set up not self-settled to begin with, particularly for aggressive, clients in states like California, where there could be some aggressive laws that try to claw those assets back into the state of California. So one of the ways that we're seeing some practitioners go about drafting these asset protection trusts is that they set up the asset protection trust just as a third-party asset protection trust, but with somebody, usually a trust protector, has the power to name the settlor back in as a beneficiary. And then that's how, so if something were to occur later, it could become a self-settled asset protection trust. So it's sort of just an additional added protection. You still get all the benefits of, right, maybe you're locking an exemption, you're moving assets to Nevada, but you're not necessarily overdoing it. So that's sort of how all of that works in context. And again, I'm very biased, but Nevada is considered the best, I think, on every chart you look at. And it's for those sort of two initial reasons of the statute of limitations and the fact that there's no super priority creditors.
Well, just to jump in, I think it's an interesting concept when you think about it. If you try and put your assets outside the reach of creditors, there's obviously an initial questioning. It's a little odd, to say the least, if you want to be kind. And then you're looking at why. So in using these 15, before we get to the third party, back to the self-settled, the question has to come up when you're meeting with folks, what is the focus and why is it? Why is that the focus? So the threshold issues is there an existing claim? Is there a potential claim? Could that happen in the near term? Those kinds of analysis, those questions need to be reviewed and answered. And then you get to the second question, well, how is it going to be funded? What is it made up of? What are the terms? If you see a situation where all of the assets are being shoved into the asset protection trust, it's probably not just a red flag. That's a sign to maybe caution the client and refer them to somebody else. But the idea behind it is so important to a lot of prospects, that you're going to deal with. And it's important to understand the nuances. That's why Kristen went through the details. It is utilized. Certain professions have a higher degree of exposure, and there is no existing or even likely claim. But in order to sleep at night, these are tools available, and these are how to do it. What we've seen in a couple situations is somebody, appreciating the other benefits. They want a dynasty trust. They want the flexibility that the Nevada statutes provide, as well as Delaware and South Dakota and Wyoming and the others. And then the attorney bolts on the asset protection piece. And that's not a great idea. That could create exposure for you in a malpractice area, because Murphy's Law, that will likely be the one that has some kind of a creditor claim pop up. But it also just, all these I's need to be dotted, the T's need to be crossed to make sure that this is done right. There are notice requirements or nuances within the law that are critical that this get done. And then, we see a variety of situations, and many of you represent trustees and likely institutional trustees, but also in working with the clients, understanding what the primary objective is, and then working with the trustees to understand prior to accepting that role, how it's going to play out, what the goal is. Are there distributions necessary? Are they contemplated at all? Is that unlikely? How is that, look forward a little bit and understand how this is going to be utilized. And, I can share with you from our standpoint, we're not necessarily endorsing or lobbying for more asset protection trusts, but it is a tool that is very useful and attractive to some folks, and it's critical that it be done correctly. So with that, we can move on to the third party aspect of this. It's a little friendlier, a little easier to navigate.
Yeah, definitely. The third party aspect of this is not only easier to navigate, but it's really the optimal form of protection. So, right, if you've got a child, I can think of a client who's got a child whose daughter's a gynecologist, right? There's a lot of, or excuse me, an OB/GYN, and that's a high risk profession these days. And so, it's one of those things. So the parents are setting up a third party asset protection trust in that case for the benefit of their daughter. And right, pretty straightforward, just as we talked about, right? I think most of you know what a third party asset protection trust is. It's just a trust established by the grantor for other beneficiaries. The grantor can retain quite a few powers in those trusts. They can fire and hire trustees. They can have investment control in a directed trust situation. If you have a complete gift, you can keep a lifetime or testamentary power of appointment. The trust must be fully discretionary to get these maximum creditor protection benefits. And, if you think about things like a slat is often an asset protection trust, right? Because it can benefit the grantor spouse. So something to keep in mind. The point sort of being that if a client is sued while they're a resident of a non-domestic asset protection trust, so somewhere like California, the trust should be designed to still provide these creditor protections, even though because it's not self-settled, it should still be fine. So that's sort of the point. And now we did promise that we would compare. So upfront, sort of when you look at every comparison everywhere, I mean, AI Gemini and ChatGPT and all the things will now do it for you. But I do think there's much more reputable places to get all this information. And so in general, Nevada and South Dakota are sort of considered the first tier in terms of their statutes and how they're written. Alaska, Tennessee, Delaware, and Wyoming are sort of the second tier. And I'll sort of tell you why. It's because Delaware does have statutory exemption creditors for child support, for maintenance, and for marital property. And they also have a 4-year creditor statute of limitations. Alaska and Wyoming have the same 4-year look back statute of limitations for future and pre-existing creditors, whereas Alaska then has an exception for marital property, and Wyoming allows it for child support. So depending on where you're drafting, those are some things to keep in mind. My understanding is that South Dakota, which is pretty new on the scene for those of you who are sort of in this game, that they pretty much mirrored Nevada's statute when they were creating their asset protection statutes. So really the only real difference is that South Dakota does allow an exception for divorcing spouses in regards to transfers that were made prior to marriage. And then in those cases, they require notice to your spouse. So that's sort of the small difference between South Dakota and Nevada. This is just kind of a joke, but it's not. Before we get into things that are more, I guess, more substantive, I do think it's really important to talk about the efficiency of the court system in different states. I cannot pretend to be well versed in all of the Big Five's state court systems, but I can compare Nevada to both California and Arizona, which I'm licensed in Arizona. I've done quite a bit of work in both Arizona and California, and neither of those are particularly efficient. I'm sure I'm preaching to the choir with all of you who do practice in California, but a probate in Washoe County, where I reside in Reno, It's timely, it's efficient, it's incredibly well run by our local county probate commissioner. And for any of you who have done work in Clark County, which is where Las Vegas is located, I will note that there used to be some pretty serious delays by our standards in Nevada for a number of years, but we have now hired a second probate commissioner. And so that's been really beneficial and helpful for the system and to keep things moving. Bob, do you want to talk about directed trusts?
Sure. Yeah, I love that ad. I think I got a call a few years ago as the lawyer in the family from my nephew. And it's funny how he honestly, for a split second in his current state, thought there was some legal protection saying what happens in Vegas actually stays in Vegas. So that is an interesting approach. We see a lot of directed trusts. We think it's a great vehicle for a lot of families that have unique or concentrated positions. Unique assets can be the family business, can be a specific holding. My favorite when I started several years ago was a minor league baseball team. The family loved this team. It was part of the family kind of culture or what they believed in. It stood for a lot of things that are really kind of just core fundamental. This was a Midwestern kind of family beliefs. Yet they agreed, and we agreed quickly with them, that we would not be ideal to run their minor league baseball team. So quickly in the planning process with the attorneys, found ourselves in a directed trust situation, which seemed to be, truly a win-win. They had complete control to do whatever they wanted. And if you remember some of the minor league, different things that were tried to get people in the stadium, we really didn't want to be, nor did the trust want to be exposed to some of those opportunities for additional marketing. But they liked it. They really enjoyed it. And it was more of a hobby. This wasn't where they made their money. This wasn't where they were going to continue to support the family and next generation. So it was an interesting aspect that highlighted in a number of ways the benefits of a directed trust. As Kristen has in this slide, all states now have some version of a directed trust statute. California recently adopted one. There are a variety of versions, really, but the bottom line is they're all pretty similar. The difference, just to touch on it very briefly, is California's does have, at least could be argued, a monitoring requirement, and Nevada's and many others are a complete exculpatory approach. There is complete isolation in these activities, which, again, for those of you representing trustees, those of you even explaining these for the clients, that's a critical piece. Do they want complete autonomy in the operation of that asset? And those are unique assets, family businesses. We shift to what's commonly, what we're seeing more and more of is a block of Apple stock. That's the majority of their wealth. NVIDIA stock more recently, AI-related companies. That has now moved from a minor position in the overall portfolio to a more prominent, concentrated position within the portfolio. And those are things that can be adjusted over time to shift to a directed trust to address those. They may or may not want to part with that or trim that exposure. The capital gain consequence is pretty significant, and they may like the holding. So a directed trust works well for that. We saw in the late 80s, I'm sorry, wasn't practicing that far ago, as Kristen, despite what Kristen may say. But in the 2008, 9, 10 period where real estate values declined significantly, we saw the balance of the portfolio shift to take, some real estate assets, and now they were a concentrated position. This was an area where that could solve the problem. You could still function in a variety of ways, but the ultimate risk is then accepted and borne by the proper party, the family that wanted to retain those legacy assets. And in most of the Western United States, real estate is a fundamental part to their net worth, to their holdings, to their income, to kind of the family core beliefs and values. So I think directed trusts are really an area where they are being recognized as more useful and being utilized more effectively over the last half dozen years. And I think they're going to be more and more important as we kind of see this concentration of wealth continue. Most trustees are more than comfortable with marketable securities, but at some point there gets a concentration level that's too high. And then you have a significant consequence. The The one war story I remember vividly is a client with a large position in GE. Each year, the individual client advisor sat down with the family, it was a couple meetings a year, and each meeting raised the issue. And the client in each case said, I was one of the early shareholders. I'm never selling this stock. And so we shifted that to a directed trust, moved the entire position over, and each year, again, asked him to reconsider, trim it, and each time it was absolutely not. So as you can see where the story was going, GE is now a fraction of what it was. The children who were in those meetings heard their father take his position, immediately threatened to sue the trust company for letting that happen, letting that dramatic decline in wealth, that evisceration of their family wealth happen. So these kinds of things are tools that we all need to look for and continue to document and have the conversations. These won't act as a complete safeguard in many cases, but that together with proper communication and addressing these issues up front and consistently will certainly help should those situations arise. So with that, I'll hand off to decanting and more exciting Nevada
No, directed trusts are
legislation.
incredibly important in what we're all doing these days during the great wealth transfer, right? And I think that also highlights the importance of decanting, right? A lot of us are dealing with very old trusts, maybe not some great provisions. And many practitioners, trust companies, research groups, better than I, have analyzed decanting statutes and attempted to determine who has the best one, usually based on things like ease of use and flexibility. One thing I will say is, despite those charts, what I found in practice is that some of the quote unquote lower ranked decanting states/statutes may actually be the better option for some of your clients because of the unique flexibility they provide. So similarly, this is, our presentation, so I'm going to give my opinion, is that I actually don't think that the adoption of the Uniform Decanting Act, it's not necessarily a bad thing, right? Because it does mean that it allows for decantings to occur, but it does lead to a pretty average statute, in my personal opinion. And so states that don't adopt the Uniform Decanting Act usually have some greater flexibility. That's a place to start if you're looking to do some unique decantings. Just a quick before we sort of dive into the quick comparisons on the decanting statutes, I mean, I think most of you here joining this presentation know some of the common reasons for decanting. These are ones that we see all the time, right? Maybe you need to change the governing law. There's an ambiguous term. Are you trying to extend the term of a trust? Meaning like from mandatory distributions to like dynastic, right? Changing the support trust into a discretionary trust, modifying powers of appointment, merging or separating trusts, right? Maybe you have a pot trust, changing some of the trustee powers, or potentially creating a special needs trust. Those are the reasons, at least I'm commonly seeing. And this is, again, wasn't going to pretend, like I said, there's research groups and other people who have created analyses on state decanting charts. This is the Steve Limberg and Steve Ocean's chart that's available on their website. It's also, I think you guys have these materials. But what this really tells you is that Nevada has a very broad decanting statute, according to this chart, arguably the second most broad, according to this chart. Some things that I think were important, and when you think about when you're comparing these statutes, are things like, does the beneficiary have to get notice of their decanting? Can you remove a mandatory income interest? Can you grant a power of appointment to a non-beneficiary in the second trust? Some comparison points that I think are interesting is that Nevada and South Dakota are nearly identical in that they don't require this notice to the beneficiaries. But from a corporate trustee perspective, right, where Bob and I are now sitting, or for any of your clients, if you're representing any trustees, individual or corporate, I think it's really important to know that Nevada law provides a protective feature to trustees who decant. So there's a statutory right of the trustees to either send a notice of proposed action, a non-judicial settlement agreement, or to petition the court. So if you represent trustees, that you're to give notice that you're decanting or to get sign off. So if you're representing trustees who are maybe hesitant to decant, I think it can be really important to just emphasize that. And so that sort of leads to, I keep saying NJSAs, so I'm sorry, that is such our shorthand for saying this, which I know is not necessarily a thing in California, but a non-judicial settlement agreement. which, these are really, really important. So notices of proposed action, non-judicial settlement agreements, right? Both of which are very well established in Nevada. And we sort of put the statutes on the next couple slides. So this is the non-judicial settlement agreement statute. And I'll let Bob sort of touch on that for a tiny bit. But
I'll just make a few comments. Similar to the directed trusts, non-judicial settlement agreements are one of the more utilized tools kind of in the arsenal, in the available statutes for Nevada. And there's similar statutes in other states, but as is described here, and you can look at it later, the key is the ability to modify an irrevocable trust after creation. And it's for a limited set of uses, but they're extremely broad. And a lot of times we're trying to move a trust from California to Nevada, add a directed trust provision to it, things like that, that are staying within the principal purpose of the trust. But all parties agree and are available to sign off, all indispensable parties, which is critical. Then you can do this very quickly, very easily, without court involvement at all. And so one of the ways we see this more often than not is the opportunity to move it to Nevada, decant, certain provisions, get it to Nevada, modify the trust to reflect the current goals and objectives of the family, make it a little more tax efficient, modify certain provisions for what evolved into a concentration or a unique situation. And everybody's on board and everybody's pleased with the outcome, at least for the time being. It doesn't solve the problem forever because times change and things come up, but it gives us the ability to modify the current irrevocable document. So we see this and utilize this particular statute often. And it often, if there's additional protections needed, works hand in hand with the notice of proposed action should, that need arise. That's very rare, but what we want to do is make sure that all the pieces fit and everybody's on the same page and all transparent, all fully disclosed. And I think, again, putting us and your clients in the best position possible to move forward without any more attention or strain, which is something that's a nice, I'd like to win the lottery as well. But certain things that are, in the moment objectives we can help a client with. And this is one of the tools that has become very effective.
yeah, and I think it's really important to mention, right? I put this indispensable party slide up on the board, right? So if you go back, right, you can do all of these amazing things, terminate a trust, change how trusts are invested, add terms, delete terms, you can essentially do almost anything you want with a non-judicial settlement agreement, but it does require all indispensable parties to sign off. So when you think about the way we draft irrevocable trusts, right? Well, what happens when you have minors or, of course, future generations who are not yet born? That's, of course, the one we're all dealing with on a regular basis. And fortunately, in Nevada, we allow for what we call virtual representation. I call this the unsung hero of Nevada law because it doesn't get the time and attention that it should get. But it specifically provides that a minor, incapacitated, unborn person or person whose identity or location is unknown and not reasonably ascertainable may be represented by another person who has a substantially similar interest with respect to the question or dispute. So long as there is no material conflict of interest between the person and the representative with respect to the question at issue. So in very basic terms, what that means, 90% of the time, 99% of the time, if you have a minor or an unborn person who's not represented by another person, right, like a parent or guardian pursuant to the statute, then they can be represented basically by the person who's standing in their shoes. So, if you've got a 25-year-old kid, they can sign on behalf of themselves and all their heirs, successors, and assigns. So yeah, it's pretty great. It really allows us to not have to go to court all the time, basically all the time, unless there's really a need to go to court, petition the court for some sort of approval. So it's really the unsung hero. It's hard to even downplay how important that provision is. So
yeah, and most everybody on this call is very familiar, probably intimately familiar with the guardian ad litem issue. And this essentially solves that for the appropriate cases, which even if you're not in court, you're stuck with that unborn, that minor, you're unable to move forward without this type of statute or getting a guardian ad litem and going to court. So it's hard to overemphasize how important the virtual representation piece has come to fit with all the other pieces we've covered today, and why that makes some of these states, Nevada in particular, is Kristen is passionate about, extremely, friendly to manage and accomplish the family's goals and objectives.
So speaking of goals and objectives, we are going to talk about silent trust, and I'll move through this relatively quickly because I want to be cognizant of time. But basically, what's a silent trust, right? So a silent trust can really do one or more of five things. So it can prohibit the disclosure of the existence of the trust. It can prohibit or restrict the release of the trust agreement. It can prohibit the disclosure of assets or other financial information related to what's in the trust. It can prohibit the release of an accounting, or it can allow the trustee to redact. Those are really the reasons that you might have a silent trust. Something I think is particularly important is that just because a trust is secret or silent, it does not mean that nobody knows, right? The settlor knows about it, the attorney who drafted it knows about it, the accountant may know about it, depending on the type of trust. The IRS may know about it, depending on if there's a return required. The Secretary of State may know about it. If there's a business filing, the SEC may know about it. The governments, both foreign and domestic, may know. Of course, when the Corporate Transparency Act was being considered, that was a big concern. Bankers, title companies, and financial advisors may know, and the recorder's office may know. And so why are our clients looking to set up silent trusts, right? The first one, the most obvious one that we see is beneficiary concern, right? They're unable to manage information because of their age or their maturity, and they don't want to disincentivize their young children. That's pretty common, maybe the number one reason that we see. You have privacy concerns, right? Those are historically high-profile individuals, but now it's also being done for identity protection purposes. Maybe you're giving unequal distributions to someone. So, you don't have litigation or deal with that. So maybe you want a silent trust. Maybe you want to protect your beneficiaries from bad actors, so creditors or divorcing spouses. And of course, the last reason could, of course, be to defraud because you want to hide assets. That is almost never happening, just transparently. I think that's what people tout when they're afraid of silent trusts. And I am not obviously a proponent sitting up here telling you that silent trusts are, I'm actually hoping to kind of convince you otherwise, that silent trust should not be your default because they don't work for many people, or they should only be silent for a period of time. But of course, defrauding does happen. So, but what are our practical problems, right? When you think about silent trust, as I said, I'm not going to be the person who's sitting up here today telling you that everything should be a silent trust. One is, of course, distributions. So how do you make a distribution without disclosing the existence of the trust? The second is tax compliance, right? Do you have a K-1? Do you have distributable net income? Do you have flow-through tax treatments? How are you dealing with that if you can't disclose the existence of the trust? What about crummy powers? Can't send a crummy notice to someone who doesn't know about the trust. About assets, how about titling, right? How do you properly title something if you can't disclose the information? So sometimes that's avoidable, sometimes it's not. And banking and financial transactions. So high level, can you continue to operate if you have a business, for example, your business without some form of disclosure? We have a client who is currently going through this struggle where they have some silent trust set up and they are looking to refinance a loan. And in order to refinance the loan, there has to be some form of disclosure. And it is an absolute nightmare. It's just an unforeseen nightmare that I don't think the client anticipated or was anticipating. And it's really been difficult to deal with. We're getting to the point where some form of disclosure is just going to have to be made to one of the beneficiaries, unfortunately. But it just sort of, those are things that when you're thinking about silent trust, maybe that's not what you're thinking about. And it's definitely not what your clients are thinking about. So just be careful how you're framing a silent trust, because at the end of the day, you're the one who's going to have to answer to the client when they get frustrated. So the other yeah, go ahead.
Well, yeah, you'll get to that in a second. Just to add on to that, the client in particular would be a traditional success story. Came to the attorney outlined a number of different options. And in this process, as Kristen said, highlighted, okay, there are these features. And of course, we don't want to disincent the kids. We don't want to alter their their future, their trajectory, by losing momentum to actually make it for themselves. But like many of your clients, especially the family business, the business owners, those folks have they've succeeded at what they do. And it's very relatively simple. They get up, they go to work, they do extremely well, they go home. And then they meet the estate planning attorney and tells them, we've got to deal with your estate tax issue. So now they had a very simple form of life where they could access a few different buckets to expand, to develop, to go into different ventures, to acquire more inventory, whatever it is that they needed to do. Now those assets are in different buckets, as Kristen explained, and those buckets aren't necessarily as easily accessible to start with. And then when you add a silent trust feature, and the children also happen to be in the business and were, not intended to see those components, all of a sudden you had a months-long emotional struggle to try and figure out how they can accomplish the financial, the business goals, yet not blow up the trust they created. And that is not uncommon. I think, similar to asset protection trusts, these need to be very carefully thought through. And as you work with trustees in this process, understand how best to deal with that. As you can certainly, understand if there is no notice, if there is no knowledge of statements of what the assets are, the inflow, the outflow, all those things that create statute of limitations for us trustees, and put them on notice. If those things don't exist, we really are in a tough position to figure out how to navigate what our exposure is and how best to manage that. And Kristen will get into some of, there's a proxy, there are a variety of ways to mitigate that to some extent, but it's an interesting dynamic.
Yeah, it's a really, really interesting dynamic. And I think I do want to highlight for those of you, because again, geographically, Nevada is the closest geographically to California. Many of you are maybe drafting Nevada silent trusts. There's a couple of things I do really want to highlight for those of you who are drafting these types of trusts. One, if you're not currently drafting Nevada silent trust, just know it's not a separate statute. It's NRS 163.004, which is our trust accounting statute. That's where Nevada's silent trust laws sort of fit in, is to not require the need to account. You should also know that the default in Nevada is silent. So if you don't, unless you have conflicting provisions requiring an accounting and requiring other types of things that would make it not a silent trust, as we just sort of talked about, that is the default in Nevada now, is actually a silent trust. So again, if you're drafting Nevada trusts, please be particularly careful about how you're drafting. Our statute does not specifically mention a designated representative, right? If you are familiar with Delaware's silent trust laws, then there has to be a set period of time in Delaware. In Nevada, that's not the case, but I would still urge all of you to draft with an end in mind for when a trust is going to be, the end is not going to be silent, right? Because again, do you really want to have trusts that exist in perpetuity forever and ever and ever with nobody being held accountable? You never have to account. You never have to, when all of us are long dead and our clients and their kids, does it make sense to really have a silent trust continuing on? So, one thing that I do think is particularly important to talk about, this is a case that I've put on the screen. It's a Nevada case, which is a silent trust case without saying it's a silent trust. At the end of the day, the Nevada Supreme Court did uphold the right to silent trust in the state of Nevada. So there are some drafting considerations, but I want to be very cognizant of time. So the very last thing that I think, so I do think, look at these. If you're drafting these trusts, please, please, please think about these things and draft in a manner that makes sense if you're drafting silent trusts. But the last thing I really want to touch on, because Bob did talk about the rule against perpetuities, which is 365 years in Nevada. South Dakota and Alaska are perpetual. Delaware is perpetual, except real estate's 100 years. So in case you were here for all my comparisons, there you go. But the last thing I want to talk about really quickly in Nevada is privacy. It's really all the big five, but it's privacy and confidentiality. And that is that there's no public disclosure of trust documents or the identity of beneficiaries. That information is very easily sealable. But there is a case, which is a direct result of the Murdoch family dispute, which I think everybody who lives in this space is well versed in at this point. It's called New York Times Co. versus the District Court. It's a Nevada advanced opinion, as we sit here right now, just came out at the very end, like less than 2 months ago, by our Nevada Supreme Court. we have sort of an evolving landscape on this. I used to just say that you could very easily seal, anything could be filed under seal. It was a very easy process. That's how we were handling complex, maybe high publicity trust matters. Well, the very high level summary of this case is that the Nevada Supreme Court concluded that the district court erred by determining that the statute removes its discretion to consider redaction instead of sealing. So, and also that the public's interest in the case was not de minimis, and so the public has a right to access. Those of us who operate in this space are not super content with this ruling. I'm involved in a legislative board. It's actually the probate and trust section of the Nevada State Bar. We hire a lobbyist. We're very active, and so we're in session. As I mentioned, our legislative session only meets every other year. We're in session this year, and there's probably some changes coming to some of our sealing procedures. And so just some of the process for how we go about public discourse and public access to information. So stay tuned. These things are evolving, even in Nevada, but they're evolving everywhere. And so I just felt like it was important to talk about some of that. I think everyone's also aware of what's happening in Delaware. There's a lot of interesting things happening in Delaware with their court system as well, particularly as it relates to corporate matters. So I think sort of on that note, I mean, I want to wrap this up. I think Nevada is obviously the best. I want to be very cognizant of everybody's time, but I think all of the big five are worthy of consideration when you're thinking about what your clients, what fits and what works for your clients. So Aubrey, I can turn it back to you so you can close.
Thank you, Kristen. That was wonderful, you guys. Want to extend a massive thank you to both of you for presenting. That concludes our program for today. Our next program will be on March 17th, which will be our annual updates from the probate judges. So that's a lot to look forward to. Thanks again, Kristen and Bob, and we'll see you next time.